Okay, I am going to begin this webinar, granted perhaps a minute early. I hope everyone will forgive me for doing that. But I think that it shouldn't be too much of a problem. Hi, my name is Dan Timins. For those of you who know me, my name is Dan Timins. You know who I am. I'm a trust and estates and elder law attorney, as well as a certified financial planner in practice in New York City. And today I have brought together myself with two other incredibly knowledgeable attorneys to speak about Medicaid and elder law planning. Before we get rolling, I do want to bring people's attention to how to use Zoom. Everyone has been muted except for our speakers, who are Irina and Michael. I'm going to place them on mute for the moment so that they can be ready and jump in when their time comes in. Otherwise, I did want to discuss really quickly how to use Zoom. Number one, when you're using Zoom, I want you to look for the green and red bar that you have. That green and red bar at the top or bottom of the screen is going to be your Zoom bar. You can go to that bar and you are able there to control whether or not you want to ask questions. So where you see Q&A, that's where you're going to hit for Q&A, questions and answers. So keep that in mind when the questions and answer section begins. That's where you'll be doing it. And I'll let you know, you can ask questions throughout as a side note, but generally speaking, I'm going to try to be attempting to keep questions answered later on into the program. So I hear the bells chiming in the background. So without further ado, let's begin. Hi, my name is Dan Timins. I'm a trust and estates and elder law attorney. We already went through that. So let's go through right now really quickly, just a quick update of what happened last time or since last time we had our last webinar. Last webinar, as you may recall, was 2 weeks ago. We were discussing virtual witnessing and virtual notarization. Virtual witnessing is something that was completely new. I said that it wasn't going to be permitted, and then lo and behold, while I was having that webinar, Governor Cuomo, in his wisdom, decided to allow virtual witnessing as well as virtual notarization. So I was wrong. I just didn't know it. It was almost literally the exact same time. So there you go. Now we have virtual witnessing. That sounds great, but it has its whole different sets of problems. You remember virtual notarization is where a notary is notarizing your signature and they're doing it from far away. In this case, over a computer or some other area. So that seems to be great during the age of COVID. The big problem has been, especially nowadays, that you still need to find people who are able to scan or fax you information back same day. The other thing you need to watch out for is that we have a situation where you need to actually have a printer and have to know how to use a printer or a scanner. More importantly, now we have virtual witnessing as well, and virtual witnessing has its own problems. Virtual witnessing says that witnesses can be in the same room or can be in a different room. So it can really be a pain in the neck for those people who don't know whether or not they want to have their witnesses present. And if they are not present, we have a whole bunch of new problems. You know, when I'm notarizing someone's documents, I'm normally notarizing the client's documents, like on a power of attorney or a trust. But with a will, I'm actually witnessing or notarizing the witnesses' signatures. This is clearly a big problem. This has been an issue throughout. And we're just trying to figure out what exactly we're supposed to be doing with virtual witnessing, because a whole bunch of things come up that are problems. You still need to have a printer. And if you have no video camera or phone on your computer, excuse me, no video camera on your phone or computer, what do you do? So virtual witnessing has its own host of problems, and we're just going to have to start learning how to deal with this. It's not a great thing. It's clearly a short-term fix, and there are things we're going to have to be working on in the future to make sure that this is done correctly. So the question is, if I don't have estate documents now, what do I do? Well, I say you still want to do those estate documents. You want to execute your documents. However, you will want to choose to do your documents and review with your attorney the witness information, because you want to know if your witnesses are going to be on-site or off-site. You're going to want to be executing remotely, and if you do, you want to schedule a time to re-execute them at some point in the future. Then last but not least, be ready to pay a little bit extra after you go to your attorney to re-execute those with them face to face. Because seriously, it's a big problem. It's a matter of people litigating matters in the future. And just because a case may be a bad case doesn't mean that one of my colleagues won't be doing something to question that. So I hear a little bit of reverb on the background, so I'm going to be placing everyone else on mute. So if you haven't done so yourselves, I will place you on mute in just a few moments. If you have more questions about virtual witnessing or virtual notarization, please watch our last webinar. So today we are talking about Medicaid. And if you don't know what Medicaid is, you may be in the wrong room, but basically Medicaid is a program that is paid for by the government. It is for indigent families to pay for your personal care. And it is done for home care or institutional care. It's funded primarily by the federal government, and it's administered at the state and county level, where certain coverage, exceptions, and costs apply. This program is for people who are aging, disabled, or who may become disabled. Here are just some of the examples of the people that this may qualify for. If either you or a family member have any of these issues, this conversation is for you. And again, I apologize for the reverb before. I'll make sure to mute everybody else. So the two phases of Medicaid planning, and today we're going to be going over somewhat of both. The Medicaid planning aspect, but also the Medicaid application process that happens later on. Most of the planning, of course, is done up front unless someone has an illness such as a stroke, in which case we need to do the planning and the application typically pretty close to one another, as in, days within one another. Not the best way to go about doing things. So without further ado, I'm going to pitch this off to my more knowledgeable colleagues, and those colleagues are Michael Lamagna and Irina Yadgarova. Both are the big shots in the estate planning world. They can answer things that may be beyond my scope and certainly are the experts in this field. So we are going to be starting with them. I'm going to pitch it off to them directly. And so without further ado, I'm going to be unmuting both of our speakers. And last thing, again, if you have questions, I want you to look for that question and answer bar that's at the top or bottom of your screen, and you'll see where it says Q&A over the green or red bar on your screen for Zoom. That is available for your use. So that being said, feel free to ask questions along the way, and I have brought in Irina and Michael. Take it away.
Okay, thank you, Dan, so much for that wonderful introduction. Unfortunately, it's times like this that get many of us to start thinking about our estate planning and certainly Medicaid planning. So I'll kick it off with talking about the current Medicaid home care application process and eligibility. And then Michael will discuss some of the changes that are very important changes that are coming down the pike. So just to take a step back, when we're discussing Medicaid, I think it's important to highlight what's so significant about this insurance program. Some of those facets that Dan mentioned, I think it's important to note that all seniors will have Medicare, but the crucial difference is that Medicare does not cover long-term short-term acute recovery. As a matter of fact, when an individual is not getting better or rehabbing, Medicare coverage is not effective. So this is why it's so important for many seniors and especially disabled individuals to start thinking about how they may begin qualifying for Medicaid and have that long-term care coverage that's very significant and crucial to them. The only other alternative really is a private long-term care policy that unfortunately is very cost prohibitive for most individuals, but should certainly be contemplated when we are young enough, and that's typically in our 40s, to be able to afford one, and hope it doesn't go bankrupt like many of them have in the past because of the exorbitant costs associated with long-term care. Okay, so we'll go over the requirements, and just keeping in mind that what Michael and I do in our respective practices is actually help people become eligible for Medicaid through what we call Medicaid planning and the process of transferring assets into various types of trusts, as well as engaging in other types of outright transfers. And so this information is really important, and to keep in mind that these income and asset thresholds that we'll be discussing are for individuals who are over 65, as Dan pointed out in his introduction, aging for Medicaid purposes, that's over 65, blind, or disabled. So the income threshold, as you see on the slide here, is $875 a month in income for a single or unmarried applicant. For a married couple, that monthly income is $1,284. Now, again, if we have excess income, we'll talk about how we can get eligibility regardless. The asset threshold is $15,750 of total assets. It's about $20,000 for a married couple, and that excludes the following exclusions. So we have a primary home, that must be a primary residence if it's to be excluded, with an equity not exceeding $893,000. One vehicle is also excluded from counting into that resource limit. Life insurance with up to $1,500 in cash value. Cash value does eat up that $15,750,000 exemption otherwise. Qualified retirement assets that are in payout status. Payout status meaning that it is paying out typically the required minimum distributions, and if an individual is under the RMD age, they can actually request and have it put into payout status. An irrevocable burial trust with an unlimited amount is exempt as well. So those are some of the exempt assets, okay? We are ready to move on to the next slide. So for current Medicaid home care application and eligibility, as you see there on the slide, there is no look back period. What that means is when we engage in the transfers, for example, if we set up a trust to shelter some of that excess resources, or even transfer to individuals, we can apply for Medicaid immediately. As soon as your bank account limit, your bank account balance is showing the appropriate threshold value, so it would be under that $15,750 for an unmarried applicant, and the assets have been transferred, that person is immediately eligible. There is no look back. That is, of course, for community Medicaid, because when we're talking about institutional Medicaid, which is really outside the scope of this webinar, there is a 5-year look back. And Michael will talk about some of the changes about the look back period. But for now, there is no penalty, no look back period. So
and maybe Irina, you could explain what community Medicaid means, what exactly that means.
So community Medicaid really is Medicaid for an individual who's residing in their residence. It covers rehabilitative care. So even short-term stays in a rehabilitation facility or even a nursing home, as long as there's intent to return home, community Medicaid covers all of that. And again, community Medicaid can grant an individual the right for a home health aid and for all sorts of chronic long-term care needs. And that is why it's so important. I just want to take you guys through a very quick hypothetical so that we can understand like a very simple example of, what this means, that there's no look back period, and what is the simple example of Medicaid planning. So we'll take a hypothetical individual. Let's say that individual is retired, 75 years old, not married, and I'm just going to give that person $115,000 in the bank, $400,000 in a 401k. This is just a hypothetical to walk you through so you understand a simple example. We have him owning one home that's a primary residence that he resides in that's less than $893,000 in equity, so that home is exempt. Let's say he also owns a co-op. And so that's his resources. Okay, so once again, $115,000 in the bank, a 401k that's around $400,000, a home that's a primary residence, and a co-op. On the income side, because Medicaid always looks at the resources and the income, on the income side, let's say he has $875 in Social Security retirement, $1,000 in the rental income from the co-op, and $500 a month from that 401k. Okay, all completely hypothetical numbers. So what would we do? On the looks of it, you would think this individual is not eligible, right? So with Medicaid planning, we would transfer the co-op, which is not exempt.
Irina, I think your connection dropped out. Could you repeat that?
I'm sorry, I was having a call through. I apologize. I'll back up a little bit. So on the resource end, we have $115,000. So if we recall, $15,750 is exempt, and the $100,000 extra presents a problem for us. So as well as the co-op, right? Because the co-op is not his primary residence. He owns it as a rental, as a means of rental income. So we would take the co-op and the $100,000 that is not exempt, and we would transfer it typically into an asset protection trust. The mechanism and the scope of which is beyond this, the scope of this webinar, but I just want to explain the basic mechanism. So we would set up an asset protection trust for those non-exempt resources. The 401k is exempt in and of itself because it is in payout status. He's 75 years old and he's getting the $500 a month in payout from that 401k. So although the resources we've dealt with, now we have the income that we have to also make sure to deal with so that we become fully Medicaid eligible. The $875 monthly income in Social Security is exempt because it meets that threshold. So we have $1,000 excess from the rental income and the $500 from the 401k. That is a total of $1,500 excess income. That excess income, because it's everything exceeding that $875 monthly threshold, is going to go into what we call a pooled income trust. Pooled income trusts are trusts that we can set up for any disabled individual, and they are meant to shelter that excess income so that that income can be used for that disabled individual's own expenses. They can never take cash out from that pooled income trust, but any bills that are submitted in the applicant's name are paid out from this pooled trust account. So really what I always like to tell clients is it's really a roundabout way of making use of your income and being eligible for Medicaid as well. So as you see here, if you place income into a pooled income trust and transfer the non-qualified assets into a Medicaid trust or even outright, you are eligible for community Medicaid because now you have met the means test. And so really in a nutshell, that is what we refer to as Medicaid planning and how we attain Medicaid eligibility. There's also something I want to touch upon. It's the spousal refusal, and that is for, let's say we have a married individual who wants Medicaid, who is disabled, not working, but the spouse is working, no matter the age of the spouse. So if the spouse is still working, they can utilize what's called a spousal refusal. And the way that works is really it's a legal instrument that we present to Medicaid that says, hey, I'm not going to be supporting my spouse. Yes, I'm working, but my income is for me. I'm not going to be supporting my spouse. And there's nothing wrong with that. This is a legal means of protecting spousal income. There are, of course, a lot of rules surrounding this. So just briefly, if the income that the working spouse makes on a monthly basis is around over $3,000, technically, Medicaid does have the right to claim up to 25% of whatever exceeds that $3,000 amount. That's rarely done, but it certainly is a risk. And so really, there's a lot of complexity and nuance surrounding all of these rules, and that's why it's very important to work with an elder attorney like myself or Michael. And I think we can go on to the next slide. So the application process currently, because of this COVID pandemic, there are certain things that HRA is the entity that processes Medicaid and Medicaid applications. So there's certain flexibility that was enacted, and that includes self-attestation, where the district must permit self-attestation for eligibility, and so there are fewer documents that must be submitted. The individual, of course, must otherwise be eligible for Medicaid, and we explained the eligibility rules in the prior slides. For recertifications are in all sense suspended, and they're not currently required. Medicaid, for those who have been receiving Medicaid, will be automatically extended for 12 months, whether or not a recertification is submitted. So that's some good news. And unfortunately, I'm going to leave it to Michael now to cover some of the not so great news. So,
okay, well, thank you very much, Irina, and thank you everybody for attending today. You know, in New York, we had it really good up until now, where it was a system where you could transfer assets, as Irina said, and get on community Medicaid as long as you were otherwise eligible, you met the income and resource guidelines. And for years, this is how it's worked. And the only time we had to worry about a penalty or a look back period was when we were dealing with nursing home cases or people in institutional skilled nursing facilities. There was a 5-year look back for that type of Medicaid. And a look back period is the time that Medicaid will say that you cannot get Medicaid services or services paid by Medicaid for a period of time equal to the amount of money that you've transferred. So all along, we've had no look back period for community Medicaid, meaning Medicaid where you get either home health care or assisted living care. And then COVID happened. And because of the severe budget deficits, the governor decided that this was the right time to actually institute a penalty for community Medicaid. And so now, after October 1st, 2020, we're going to have a 2.5-year or 30-month look-back period. And the first bit of good news is originally they wanted to keep it at a 5-year look-back period, and the compromise was 2.5 years. So that means for any new applications, the Medicaid applications for home care or assisted living program, after October 1st, 2020, there's going to be a 30-month or 2.5 look-back period or penalty period, depending on how much you gifted or transferred. Now, the second bit of good news is this is new applications after 10/1/2020, which means that you still have the opportunity for the next 4 to 5 months to actually apply for Medicaid without this penalty period. The eligibility rules are still the same, which is another bit of good news, and some of the exceptions for penalties are still there, like transfers to a spouse. So anytime you have a spouse well, now not just the community, but a spouse at home, you could transfer assets to that spouse and still be able to qualify for community Medicaid. There's exceptions for disabled children and transferred into special trusts like supplemental needs trust. So a lot of the same conditions still exist. It's just going to be more difficult after 10/1/2020 to qualify. Now, of course, when you're going on Medicaid, you're really doing it in order to get, most of the time, personal care services or home health care aids. And so not just the eligibility portion, but there are actually changes to who's going to qualify and how many hours they're going to get. So until now, basically, you needed care with at least one activities of daily living. So transferring, toileting, eating, etc. Well, after 10/1/2020, there's going to be a heightened standard. You're going to require physical maneuvering with 3 or more activities of daily living now to qualify for hours. And if you have Alzheimer's or dementia, that only counts as one condition, and you still need 2 or more activities of daily living along with the Alzheimer's or dementia. Now,
maybe, Michael, could you give us examples of activities of daily living?
Sure. The activities of daily living are grooming, so getting yourself ready in the morning, bathing, going to the bathroom, ambulating, eating or preparing food. So those are the basic 5 activities of daily living. And these are basically Medicaid does not pay for supervision. They pay for actually physical maneuvering with these activities of daily living. So many people call me and they say, well, mom or dad has dementia and I'm really afraid that they're going to fall and they need someone to kind of look after them. That's not physical maneuvering. What is physical maneuvering is I need to take this person to help them ambulate to the bathroom. I have to help them with their personal hygiene or help them in and out of the shower, etc. You need to basically lay hands or more than limited assistance with an activity of daily living after 10/1/2020. There's also going to be an independent panel. Right now, basically, you sign up for Medicaid, you go with an agency or something called Consumer Directed Participation Program, or CDPAP. CDPAP is a program where you hire, fire, and train the aides, and Medicaid pays for them. So you have people like family caregivers, etc., getting paid by Medicaid. Well, there's going to be more oversight over the program, and they're going to require an independent doctor now to sign off on hours, as well as the agency or consumer directed program. So there's going to be heightened scrutiny for hours that are being given. In addition, part of the new law, they were going to draw a bright line of 12 hours. Anyone getting 12 hours or a live-in or more of care, they were going to have also heightened scrutiny. They left in the heightened scrutiny for quote unquote higher hours, but that's basically going to mean anybody who's going to be getting a live-in service, that's someone who gets 13 hours of care, but the person is there throughout the night, is going to have an independent panel assess that, and it's going to be assessed yearly, which is something that's also very different. So that's why it's very important right now that people that are considering to apply for Medicaid actually get their application in before 10/1/2020. However, that also means that you have to be income and asset qualified as well, meaning, as Irina said, that your income is aligned or you use a pooled income trust, your resources are below the $15,750, you've done the other planning like transferring assets into a trust, etc. So that we can, all of this takes time, 2 to 3 months generally, so we're well ahead of the 10/1/2020 date for transfer penalties. So the other bit of good news is these two concepts were on the chopping block: spousal refusal and what we call the CSRA, or the Community Spouse Resource Allowance. So spousal refusal is a huge deal. That allows one spouse to transfer assets to the unwell spouse. It's the unwell spouse to transfer, the not well spouse to transfer their assets to the well spouse and still acquire Medicaid. That still is a reality for community Medicaid. So that means that even after 10/1/2020, there's going to be the ability to go on Medicaid and transferring assets to the spouse. So the real concern is those people that don't have spouses. The other big deal was the keeping of the Community Spouse Resource Allowance. So this is the amount that a spouse, the well spouse, can keep without Medicaid instituting a penalty on that well spouse. Irina talked about, a 25% penalty of income, and there are also penalties for resources for spouses that are in the community, or spouses that actually are well spouses. So what they did is they maintained the current amounts of $74,000 to $128,840, and this was a very good thing. So, Irina and I and Dan were talking about different types of strategies to wait out the penalty period. So this is really 10/1/2020 and later, with some things that you can do. There's still long-term care planning. We still have the 2.5-year and 5-year look-back periods to deal with. So that means that the sooner you transfer your assets into a trust or otherwise, you can start these penalty periods. You can always private pay for care, especially home care, utilizing your income and assets. And we always say to go to a financial advisor and help them rearrange your assets in such a way to take advantage of income if you're paying for long-term care. There's going to be advanced Medicaid strategies and planning after 10/1/2020. There are concepts like immediate annuities, Medicaid compliant annuities, and promissory notes, which will allow you to lessen the amount of the 2.5-year penalty period for community Medicaid and the 5-year look back for nursing home care. Those will still be available. There are strategies called caregiver agreements, where lump sum of payment is given to a caregiver, especially a family member, to provide care to somebody, and it eats away at that penalty period. And there's also something called a pension called VA aid and attendance, which is up to $2,100 a month in a pension for those of our service people that have served during an active war time and were other than dishonorably discharged. And they can actually get a penalty, or if they're no longer living, their widowed spouse can get a pension, which goes towards care. So just a little bit of a summary real quick about the new Medicaid home care rules. Spousal transfers are still exempt, meaning you can still transfer from spouse to spouse, and that is still going to be allowed, both pre-10/1/2020 and post-10/1/2020. However, if you're thinking about applying for Medicaid, community Medicaid, this is definitely the time. And up until 10/1/2020, we strongly recommend it. We also know that after 10/1/2020, there's going to be a longer time to process Medicaid applications. Right now, if you're in the institutional world where there's a 60-month look-back period for nursing home care, it could take up to a year to have that Medicaid application approved. Right now, pre 10/1/2020, basically a Medicaid application takes about 6 weeks to 2 months. We do anticipate post 10/1/2020 it taking longer because they're going to have to go through 3 years of bank statements. There's also a little bit of uncertainty out there as to how some of the post 10/1/2020 asset transfers are going to be handled. Whenever you are in Medicaid, there are review times or recertifications, and there will be, since you're going to be recertifying probably a year after 10/1/2020 potentially, it's uncertain about how Medicaid is going to handle those recertifications right now. However, there's still going to be the advanced Medicaid situations, the annuities, the promissory notes, as well as if you are on Medicaid and there's a penalty instituted, it's only at the Medicaid rate, which is generally 60% of what you would pay privately for care. So all in all, applying for Medicaid is always a good thing. Irina, do you want to take some of these, or?
I'm happy to go through this slide. Yeah, I just want to also say that it will be a lengthier approval process, as Michael mentioned. It's also going to be costlier because it's going to be more expensive to submit a Medicaid application with 30-month statements for every account that you may have held. Okay, so taking you through this slide. This is education. Education is really important. We want to make sure that all of our clients are educated on the new rules to understand how important it is to start taking action now. We're encouraging everyone to start those look-back periods now. And this is a really great tip to include language in the application stating that the transfers were done prior to that look-back period starting for home care apps, 10/1/2020. You could use the self-attestation, keep collecting the needed information. There's no need to delay the process during this pandemic, and we could at least take advantage of some of these, of the flexibility that have been put into the current application process. This is a really great tip to keep all of the statements in a central location now, because it's quite often when we work with clients, we find it's difficult to access all of those statements. When we apply for institutional Medicaid, 60 months for every statement, it's a really heavy burden. And we want to start, having a streamlined process for those to be stored. And so keep a checklist of where everything is and make a list of all of your accounts. Often this is like one of the biggest hurdles for clients, is to put everything on paper, figure out where all of their various accounts, CDs, all of anything financial related. The long-term care insurance, I think Dan is much more qualified to touch upon that, but we certainly are happy to have you work with your financial advisor to look into long-term care policies. They're very expensive, and there's certainly a window of an age-appropriate time where those make most sense. One thing I will mention is that there are a lot of life insurance policies now that have a long-term care rider, which I think is a great instrument. And what that means is basically, if you need long-term care, it would eat into that death benefit on the life insurance policy, and I think that's a great option. The last bullet on this slide is, as tough as it was to get adequate home care, it's getting even tougher, unfortunately, with the Medicaid redesign and the changes that are coming down the pike October 1st. It's very important to speak with physicians and to have family support for the appropriate hours that you may require. Every hour, in my experience, has already been a fight, and of course, it's going to become that much more challenging. That's
And
yeah.
I'll just chime onto that really quickly. I mean, when you think of the financial benefit that a 6-hour as opposed to an 8-hour aid provides, you know, those extra 2 hours can make the difference for families who are perhaps trying to help on their own spare time to help with a family member. You know, every hour does make a difference. I totally agree with you.
Yeah, I think it's really it's such a shame that so many of these changes are happening because unfortunately there was so much abuse on the part of the MLTCs, the managed long-term care entities, and you know, home care, it's a business, and so there was unfortunately a ton of abuse. But there's so many people who genuinely need the services, and it's really unfortunate for them.
Very good, which I think brings us to the end of the slideshow, but that does not mean necessarily we are done. I did just want to pitch a few questions both to Michael and Irina and see what their answers are regarding them. You know, I had someone email me, and I'll just tell everybody right now that if you have questions, you can put it toward the Q&A tab at the top, which we have, and I'll be answering those in a few moments. Let's start really quickly, though, with a question that I had emailed to me during this presentation by someone who prefers to email me. They asked, what do you do right now for clients who maybe started the process but haven't gotten you all the documents? So, for example, maybe they have an outstanding statement here, or maybe a birth certificate or a marriage certificate. What are you guys telling your clients who are in that position where they still owe you documents right now?
Well, right now, so there's an exception to that, and the exception to self-attestation is anything to do with demographics or immigration status and residency. Other than that, as long as we know that they're otherwise eligible, so that the income and assets are aligned, it's best to apply in the next few weeks.
Absolutely, and again, for currently until October 1st, all you need are the current one current bank statement and proof of current income, which is often in the bank statement itself.
Excellent, good. And then I had one more. I had someone ask, what happens if you have retirement funds and you're only in your 50s?
You have to put them in payout status. That's the thing. You have to actually speak with a financial advisor and put those assets into payout status, or depending on how much they are. I have somebody that we're looking to apply for Medicaid that has, you know, $12,000 in IRA assets, and they're qualified, but even still, right now there'd be less of a penalty for them to actually divest themselves of it.
Yeah, this is. Go ahead. I'm sorry. I didn't mean to interrupt.
It depends on the circumstance.
Yeah, absolutely. This is a very common situation for somebody to be under the required minimum distribution age, and we often work with their financial advisor by giving them the number that we want to see in payout status, which is in line with the District of Social Services life expectancy chart. And so that's how we would, you know, tackle that. Or as Michael said, depending on the value, of course, you may be smarter to just cash it out.
Great. Let me open up the floor to questions that we've been receiving throughout. We have Nina ask, are you able to have us see who is speaking? I haven't done my roots, so I'm going to keep that off for the time being. But I did shave today. Okay, and there's another question from Nina, which was, how does one do a cost comparison for full-time private care and home versus applying for community Medicaid and moving assets? So how do you do the cost comparison with clients?
Well, I mean, I'll jump in real quick. So what I do is I look at about 4 hours a day. And 4 hours a day of private care is generally about $100 a day or $3,000 a month. That's usually my litmus. And usually $3,000 a month is going to be very detrimental to somebody's income. And, you know, the cost of transferring assets, putting things into irrevocable trust, et cetera, not just the financial cost, but the real world cost of doing that action and, you know, divesting yourself of assets potentially, I think at 4 hours a day is usually when I tell people it's time to apply for Medicaid. And Medicaid, I always tell my clients, is a may, not a shall, meaning that you have to weigh all the costs and benefits of applying for Medicaid before you do go forward with it.
Yeah, and I just want to supplement by saying that there are so many advantages to certain aspects of Medicaid planning, right? For example, setting up an asset protection trust doesn't mean that you have to start applying for Medicaid or even that you'll need Medicaid ever, honestly. There's so many advantages to having those asset protection trusts. For example, avoiding probate, creditor protection. There's a lot that individuals gain from the process. It doesn't mean that your end result will be Medicaid. It's very wise to start 50s and up to assess your finances, what's necessary to keep in your name and what's really just not smart to keep in your personal name.
Wonderful. We have a question from Chrisanne that I bet both of you will have a comment or at least an opinion on. Just to be clear on the new CDPAP requirements. So please give a brief explanation of what that is when you answer your question. One of my clients was told by an agency that CDPAP is being eliminated altogether. Is this true, or are the requirements just changing for the program?
So what is going away with CDPAP that we know of so far is at first, there was no requirement for Medicaid to let clients know about the CDPAP program. Then there was a change, and about maybe 6 months to a year ago, there was a requirement that everyone who was eligible for Medicaid would learn about the CDPAP program through notifications. That notification provision has been taken away. So no longer will Medicaid be so forthright to tell people about the Consumer-Directed Participation Program. What we also know about CDPAP is there may be more oversight over the CDPAP program, and there may actually be an annual, almost like the Medicare drawing a blank, Dan, the Medicare opt-in time, the time of year where you can actually go into Medicare. They're looking at a CDPAP situation where you can go in annually.
And what's the benefit? What makes CDPAP or made CDPAP so attractive so that people who aren't familiar with it know exactly what it is?
Basically, you act as the agency, the participant acts as the agency, so they can hire, fire, and train the individual person. Also, those CDPAP aides can also do things that agency aides cannot because of the regulations. They can help with medication administration, etc. So you get the added bonus of having them be able to do a little bit more than an agency aide, and the flexibility of somebody that you can hire and select. The advantage of consumer directed is the participant is hiring, firing, and training the person. So there's nobody so if the person can't show up, you have to sort of find somebody as a backup to the program.
Great. And Irina, do you care to chime in on that?
No, I think that was really comprehensive. I don't have anything to add. I think there's a lot of, I think there's some uncertainty still with regards to CDPAP, and I just think it's complicated because there's been a lot of also abuse of the CDPAP program. It kind of like ballooned, and I think the state is really trying to figure out how to contain it.
Okay. Next question from Anonymous. Does owning a home prevent someone from being eligible for Medicaid? Can Medicaid place a lien on the home and require proceeds of the sale after death be used to reimburse Medicaid? Why don't I pitch this to Irina?
Okay, so we addressed this, went over it kind of quickly, but basically when you have one primary residence that doesn't exceed $193,000 in equity, it's exempt. However, that doesn't mean that Medicaid, if a person has Medicaid and a primary residence, that you're scot-free now, because there is mandatory Medicaid estate recovery. So what this means is if a person was receiving Medicaid and passed away in New York and had this primary residence that was exempt, Medicaid still must collect everything that they paid out in the last 10 years of that individual's lifetime on Medicaid costs, and they will recover that from the home. It's called estate recovery. And it is mandatory, and it will happen if the home is in your name. That is another reason why, even though it's exempt, we always advise the homes to be transferred into an asset protection trust.
Instead of asking Mike to answer that, I'm just going to switch off question just because I want to be respectful of everyone's time and make sure their questions are answered. We have a question here from Robin. What's the difference between a pooled income trust and an asset protection trust? How much does it cost to set up a trust? And are there tax implications and annual fees? So we're looking at two different types of trusts, the income trust and the asset protection trusts. Why don't you answer that, Michael?
Sure. So income and assets are treated very differently under Medicaid. Income is recurring income like Social Security and pension, and assets are what you have in your bank, the value of your home, the value of a life insurance policy, etc. So a pooled income trust deals with the income, and as Irina had said, if you have over $875 a month in income, then technically you are disqualified from having Medicaid, other than utilizing a pooled income trust where you could put the income in over $875 a month and still be able to utilize that overage for what you need for the home, for your mortgage, etc. Whereas an asset protection trust deals with the assets. So you put your house in the asset protection trust. You put your assets above $15,750 in the asset protection trust in order to qualify for Medicaid. Now, with the pooled income trust, yes, there are recurring fees, there are monthly fees, and there are annual, well, there's at least a fee to sign up, and there's usually annual fees. But let's think about the benefit that you're getting. So other than using a pooled income trust, anything over any income over $875 would have to be put back into the Medicaid program, and most people wouldn't be able to live or pay their rent, etc. So the pooled income trust is very important, even if it is a couple of $100s a year. Generally, it's $300 to $500 to sign up initially, and there's usually a $30 to $100 a month fee to utilize the pooled income trust, but the benefit that you're getting far outweighs the costs.
Excellent. And I will ask the next question to Irina, which is from Anonymous. Do family members who are Medicaid recipients need to get training to get paid to provide elder care to family members care?
Yeah, absolutely. Yeah, no, they must undergo home health aid training.
Right. So we had a yes, and I don't know if you wanted to tack on what that looks like, et cetera, if there's anything official that they need to do.
The home care agency that they will sign up with provides the training. I think it's like a few weeks of a course, and they basically teach them how to properly assist their clients. Michael, do you have more information on the specifics of the training? I don't think it's overly cumbersome. I know a bunch of people who've gone through it.
No, but there's just an enrollment process. They do see what the immigration status is, and it's an enrollment process.
I have a question that asks, per Irina's last note, which was a few questions ago, is an asset protection trust the same as an irrevocable trust? Let me just field this really quickly because I can speak as to this. Any trust that you're going to be utilizing for your own Medicaid benefits, so your assets and you want to qualify for Medicaid, that by its nature is going to have to be irrevocable. The idea is that government agencies say, if you have the ability to say, I changed my mind, I don't want to transfer all these assets, I want to put control over them again, I want to reclaim them, that's not going to qualify. A revocable trust effectively means you're saying this document I've created, I can change it whenever I want and I can reclaim the assets or change who receives it. That's never going to qualify for Medicaid. If you're trying to create any type of trust for yourself to protect for Medicaid benefits, it's going to be irrevocable. If you are creating a trust that benefits you during your life, if you don't ever intend to or need Medicaid, and you are leaving it to a disabled individual, it may be revocable during your life, but when you pass away, it automatically becomes irrevocable with some exceptions. And then the trust that you create for your disabled family member will be irrevocable as well. So when we're talking about Medicaid planning, especially when we're talking about asset-only trusts, or I should say asset protection trusts, those are going to be irrevocable. Generally speaking, it's not going to be Medicaid compliant otherwise. I had a quick comment here just saying that they missed the question. I'll ask for just a quick answer. Question about CDPAP program, is it being discontinued or are the requirements just changing? So if you could just answer that in a sentence or two, either of you.
As far as we know, the CDPAP will be alive and well, that there'll just be heightened scrutiny for CDPAP, so there'll be more oversight over who gets consumer directed and how many hours they'll get, as well as potentially an enrollment period where if you do enroll in CDPAP, you wouldn't be able to change until an annual enrollment process. So it's a little bit murky right now. It's one of the unknowns, but we don't have information that CDPAP is not going to exist.
Got it. And we had a comment here from Joe that says starting in 2012, mid-year that CDPAP was perhaps required. It says it was not enforced ever regarding the training for CDPAP. I don't know if there's any change into that recently that anyone cares to comment on, just to answer our the question that was or the comment that was made.
No, CDPAP is basically if you think about any family member that you know of that goes home, and the hospital or skilled nursing facility trains them on how to do certain things for that family member, it's basically the same concept. So while there's an enrollment process where you do have to go through for CDPAP, there's no specific training requirements for consumer directed, like there may be in a licensed home care agency.
I have a question that I'm going to just pepper in there for the two of you. Attorneys tend to charge, of course, for, well, just about anything, but that's what we do. So when people ask, is it possible for me to do a Medicaid application on my own? I would certainly say if you have a family member who's going to be using institutional Medicaid, i.e. either going to a nursing home, you may want the nursing home to do it if your family member actually never really had that much money. And even then, I'll question it. But when people ask, is it possible for me to do my Medicaid application for my mother? She really doesn't have much money. What are we supposed to do for home care?
That's not an uncommon question. And I would say if you meet the means test without any planning, meaning if that individual is income and resource eligible, I don't think you do not need an attorney. That's I don't know, Michael may disagree with me, but I do not handle those Medicaid applications unless the client begs me and wants to pay me, and I make it very clear that they can do it on their own. If there's any planning that's required, such as a pool trust for the income or a resource transfer, then I absolutely, I would think it's a critical mistake to not engage an attorney for that.
Okay, if Mike wants to answer that, that's fine. What I've always told people is, yes, it costs money to pay an attorney to do the Medicaid application for your family member, but all it takes is a few mistakes. This isn't the old world of Medicaid where if you made some mistakes and we knew the person who's in the back office, we may be able to get it fixed. Every time that there are a few mistakes, you could be missing out on a month or 2 or 3's worth of care. And that seems to beg the question of, did you really save money by doing it yourself? And my feeling typically is no. Any parting comments or final comments that either of the two of you have before I wrap up today?
Yeah, I just want to say thank you very much. I think that these changes are very important for people to understand and know, and and not to be scared of them. There's a lot of fear mongering going out there about Medicaid and about what's going on, and a lot of myths and a lot of rumors. And Medicaid in 2005, Medicaid changed from a look back period for nursing home from 36 months to 60 months. And everybody adjusted, and the planning using promissory notes, annuities, etc., really started flourishing. It's the same thing now with the new rules that will be happening after October 1st, 2020. There's new rules that we're going to have to work with, and we will work with them, and not to be afraid. And we'll get through this and be able to make sure that people can get the care that they need.
Yeah, I appreciate that approach. That's actually a great uplifting approach for me as well, because it really was when the new rules just came out, it really was scary. But as Michael says, it's important to just do the best we can, keep going, and that's the importance of planning ahead, because planning in advance saves a ton of money, a lot of headache, and it's very important. And we gave a lot of information today. And there's always follow-up questions, and we're all happy to field them. It's not a simple world out there with Medicaid, but that's why it's important to speak with a professional about them.
And I would say my closing comments as to the Medicaid questions and issues brought up today are for those assets that are a little bit more difficult to transfer. You know, I live in Manhattan, so the first thing I always go to is co-op shares.
Yeah.
You know, is it even possible to transfer co-op shares to irrevocable trusts? And, you know, the answer is yes, but with difficulty often, et cetera. You know, think of that asset that your sick or elderly family member has that is going to be the hardest thing to get out of their name or to place into a Medicaid trust. That should be your concern. And I'm not saying, you know, there's fire, run, you better hurry and do this immediately, but there's definitely added impetus to transfer those assets. We're kind of looking at, I hate to say the end of the heyday of Medicaid, but you know, it used to just be a revolving door, and to this day, it still is a revolving door. You know, if you have a legitimate need, you're going to be able to get it, and the planning is not going to be as difficult as it will be in the near future. I wanted to thank again Irina and Michael. Irina, thank you for giving me notice of these changes more or less the same hour that you found out about them, which was soon thereafter. So I really appreciate that. And Michael, I have worked with many a client, and just both your wonderful attorneys. I really appreciate it. And like Irina and Michael were saying, if you have questions, please feel free to reach out to any of us. Thank you for your time, and we will be back in a few weeks for our next installment. Have a wonderful week, and we'll be done with this COVID-19 soon enough, I hope.
Yep, God willing. Thank you guys very much. Be well, everybody.